Tēnā koutou, tēnā koutou, tēnā koutou katoa. Welcome and warm Pacific greetings to all our listeners today. So welcome to this webinar designed to inform health professionals about what the End of Life Choice Act is, what it could mean for medical practice and our patients, and what we may wish to consider before casting our vote next month. I'm Dr. Shelley Thompson, a GP from the Wellington region, and I will be your moderator this evening. This webinar grew because I felt I needed more information before casting a vote in the upcoming referendum and wanted to hear from medical colleagues on both sides of the conversation. I was surprised that as health professionals, we have not had much discussion on this topic. However, if more than 50% of New Zealanders vote yes, it will be our workplaces that implement a significant change in the end-of-life care. It became apparent that other doctors felt in a similar position, and in the weeks that followed, I have come to understand why. This act evokes an emotional response on both sides of the conversation. It is divisive. But this webinar will not be a debate. The speakers have been asked not to tell listeners which way to vote. This webinar is an opportunity for health professionals to hear the opinions of our informed colleagues, to hear insight of a lawyer specialising in medical law, perspectives from Māori and Pacific representatives, and insight from a journalist who has spent many months obtaining perspectives from both New Zealand and abroad on the subject. You are likely to realise that all these people care and show compassion. The upcoming referendum question is only partially an ethical one. It is actually a question about whether the End of Life Choice Act, as has already been created, is a law New Zealanders support now. I encourage listeners to recognise and acknowledge the emotions this topic may create within you, but I also urge you to use the same critical thinking you employ when interpreting journal articles when you hear from these speakers. Please respect each voice and share in my gratitude for their presence today. To help officiate this webinar, I'd like to invite Hector Matthews, Chief Executive of Māori and Pacific Health Canterbury DHB, to unmute himself and share a karakia.
Kia ora koutou, nei rā te mihi atu kia koutou, aha ko nohea, aha ko kōwai, ko tēnei te mihi mahana kia koutou mea karakia tātou. Whakataua e tarangi e tūnei, whakataua e papa e takoto nei. Titia kia oho, titia kia wātea, titia ki te poho o tāne nuiarangi, whano haramai te toki haumi e hui e tai ki. Thank you, Shelley.
It's lovely to see people from, far and wide throughout New Zealand. That's awesome. But in the interest of time, I have only allowed our 5 speakers and 1 recorded video very short time to get their message across. I understand it's a very short amount of time to do this, so I'll go right on ahead and introduce our first speaker. First up, we have a partner of the law firm Washington Kearney, Adam Holloway. He is a lawyer regularly instructed by the Medical Protection Society. Adam, please tell us what we need to know about this law.
Good evening, everyone. And for the same reasons of time, I'm going to launch straight into it. I've put together a couple of slides, so I'll share my screen now and then speak to those. And at the end, I'll take the slides away and participate in the discussion. I've been given the difficult job of trying to give a bit of a background to this legislation in a few minutes. And I just want to start with something that Shelley mentioned, which is that the referendum is to vote on a law, not on an idea or a concept that still needs to be developed or that can be debated. Parliament has passed an act, and if a majority of people vote yes to that, then it will come into force 12 months after the referendum, so in around September 2021. And what that means, if there is a yes vote, we all will know what the law is going to be and we can all prepare for it. There will be, over that year run-in, a number of things which take place. The government may well adopt some regulations to help implement some of the detail of the law. The government will need to establish what's called the Support and Consultation for End of Life in New Zealand group, which has some functions under the Act. A review committee, again, another oversight body under the Act, appoint a registrar who will be an employee of the Ministry of Health. The SKENS group will need to come up with a list of independent doctors who are happy to be involved in providing second opinions on eligibility. And then there'll be a range of other bodies which may also have conversations that people can be involved in to help figure out how the Act's really going to work in practice. Again, only if there's a yes vote and the Act does come into force. There's a programmed review after the first 3 years, and then again every 5 years after that. So we do have the prospect of the Act evolving or being refined over time. So, as I'm sure you all know, the End of Life Choice Act provides a way for your patients to ask for assistance in dying. This process, as you can see, there's lots of components to it, and I won't try and take you all through it in detail, or we certainly will run out of time, but we can return to this in questions if necessary. But in essence, what the Act does is put someone called the attending doctor, and that's the person who is first asked for assistance under the Act with death, really at the heart of a process that ultimately, if the patient is found to meet the statutory test of eligibility, will allow that patient to be assisted in their own death. But it is a process which, if you as a doctor are prepared to be involved in it, is quite onerous in my view. You have a lot of obligations, both in terms of making sure the patient is eligible, providing that patient with information along the way, and then filling in an array of forms to then satisfy the oversight bodies that the process has been done properly. So that, to me, as a lawyer, raises a range of issues, as I'm sure such an important piece of legislation will do for all of us. I've put on this slide really just some of the headline things which occurred to me as being worthy of further discussion. Conscientious objection, which is provided for in the Act, so you can choose not to be involved, although importantly, even if you are an objector, you will still have an obligation to refer patients who requested death on to the SKENS group, so they can be linked up with a doctor who's not an objector, and I know that that's an important issue for some people. There's issue for me around what happens if you do change your mind and become an objector along the way. There are some process things in the Act which, in my view, haven't been completely thought through. The issues of who will be regarded as meeting the statutory test of competence and who will be regarded as meeting the test for being eligible for an assisted death are really important. The Section 11 obligations, it's a slightly mysterious bullet point, but really that's just about what the Act will demand of you as practitioners if you're prepared to be involved. And it is quite onerous in my view. I think funding could be discussed, who's going to pay for all of this, particularly the primary care level. The Act asks a lot of GPs if they are prepared to be involved, and then the medico-legal risks. So the test for competence, in order to be eligible for an assisted death under the Act, you have to be regarded as competent, but the test for competence is particular to this legislation, and it's a relatively weak test. I don't mean that pejoratively, but you only need to be able to understand, retain, and use or weigh information about the concept of assisting dying and then communicate your decision. So it's certainly a different test from the ones we all may be more used to under the Mental Health Act or the PPPR Act. So you can start to have a divergence between who might be competent under the End of Life Choice Act, but then regarded as not competent in some other contexts. Eligibility, which has probably been at the heart of a lot of the debate and certainly did evolve as the legislation made its way through Parliament. Those bullet points there set out the eligibility test. What I think is of particular interest perhaps to doctors is that it's up to you, if you're the attending doctor, to assess these things. So you will have to sign off that in your assessment, your patient has, for example, a terminal illness likely to end the person's life within 6 months. That's a difficult issue of prognosis. You will have to assess that they have an advanced state of irreversible decline, etc. So if the Act comes into force, if there is a yes vote and you are involved, these are the sorts of things that you'll be confronted with. Section 11, my mysterious bullet point, this is, as I mentioned, really just to point out that as someone walks through the door of the consulting room and says, I would like to request an assisted death, and if you're prepared to be involved in that, so you're not an objector, there immediately kicks in a range of obligations. And slightly curiously, these obligations are things which you must comply with, but they come earlier in time than your ultimate assessment of eligibility. So there will be some interesting things, I think, to thrash out if this Act does come into force around the clinical tensions of, on the one hand, having some tick boxes to comply with the Act, so you must provide certain information, explain how the Act works, and assess things like whether your patient is under duress at all, where your clinical instincts might be actually have a discussion about mood or what you can do to improve that patient's life and divert the discussion away from dying. So that I think is something that doctors will have to grapple with. And then finally, I think I've already gone on slightly over time, in terms of risks, the Act does provide an immunity from criminal liability, so the usual liabilities that would attach to assisting with someone's suicide or being involved in a homicide, provided you comply with the Act. So there is still the potential there, if you step outside the Act, to have some criminal liability. An immunity from civil liability, so that's being sued for money, and I've said mostly there because there is a remote possibility of human rights review tribunal proceedings being brought by the HDC. There are offences under the Act if you willfully fail to comply with your obligations, so it's not easy to commit an offence under the Act. And importantly and finally, there is no immunity from the ordinary channels for professional discipline, the Medical Council and the Health and Disability Commissioner. So those two bodies may well end up, if this Act does come into force with a yes vote, having to grapple with practitioners' conduct under it. So I will stop the sharing now and pass back to Shelley.
And from here, we can move right into our next, we have a video of our next speaker. It's a pre-recording from the journalist and author Caroline Trays, which was done especially for this webinar. We have edited this in the interest of time. So originally it was 15 minutes. We've got it down to like about 6, but we will make the longer version available after this and we can send it out to people. So let's listen. Thanks, Andrew.
Hi, I'm Caroline Trays. I'm the author of this book, The Final Choice, and a journalist. Late last year, I went to a freelance writing job and it was a meeting, and there I heard a little bit about assisted dying, and I came away from that meeting thinking, what is this that we're talking about? I knew that it would be in a binding referendum with this election, but little else. So I went on the journey. As part of that, I interviewed over 20 experts. So I talked to campaigners, I talked to lawyers, to doctors, I talked to those with terminal illnesses and disabilities, and I welcomed their input on the conversation, their perspective. I interviewed someone called Margaret Somerville, who has 9 doctorates. She's a bioethicist from Australia. She said, this question that we are being asked in New Zealand at this time is the most important values decision of the 21st century. And that importance was echoed through interviews with the lawyers, the Queen's Council member, and others in the conversation. To get an idea of what good lawmaking practice actually looks like, one of the people I interviewed was Queen's Council member Grant Illingworth. And he took me through a couple of questions that we can ask to test if this law is indeed robust. So questions like, Will the safeguards included be able to weed out those who shouldn't have access to this? Is the eligibility criteria, such as the one based on prognosis of 6 months, is it a reliable test? Is it a reliable line in the sand that we definitely know this will be the right person eligible? Or a question like, is 2 doctors doing their best to assess for coercion a good enough protection to ensure that someone is not being pressured into this? So an interesting point talking about coercion that I found while researching some of these laws internationally is over in Oregon in the United States, they've legalized assisted suicide. So that's a form of assisted dying where you administer it yourself. So over there it's legal. And what they found is that the average length that a doctor has a relationship with the patient, that relationship length from the beginning meeting the patient to the patient taking the dose, the average length is 10 to 14 weeks. And that's a pattern that's actually seen throughout the nearly or just above 13 jurisdictions that have legalized equivalent laws. To note, more than 30 have rejected this law and around 13 have accepted it or a version of it. So some laws contain euthanasia and assisted suicide. That's when the doctor administers that last dose or it's self-administered. And some jurisdictions have only legalized assisted suicide. So Victoria State in Australia, just assisted suicide. All of the states in the United States that have legalized this, just assisted suicide. Internationally, what you see is that in Canada, for example, there is a small portion of doctors that have agreed to participate in this process. So over there, you've got about 130 doctors from across the entire nation of Canada that will be willing to administer this. Even within that 130, there is a number, just over 20, that would be willing to be the second doctor assessing, but they won't participate in actually releasing the lethal dose. Most probably a small group within New Zealand that will be willing to do this, and the average doctor-patient relationship will be quite short. So again, is this a strong enough safeguard for a doctor to assess coercion within that context? Not only look at what is within the Act, but look at what is not in the Act. So every other jurisdiction that has legalized a form of this have what you call a cooling off period. So that's a certain number of days between when that application is made to when that person can have it administered. So generally speaking, it's somewhere between 9 to 15 days cooling off period. In our law, it's not included. It's not in there. I looked overseas in Oregon and Washington. They have some really interesting reviews at the end of every year. They produce a report. Their questions to those applying for this is very thorough. And one of the questions they ask is, what are the primary reasons behind you asking for this medication or this treatment? The number one motivational factor that people chose to take this was that they felt less able to engage in activities that were enjoyable in life. That was over 90% of people said that is why they wanted this treatment. Other factors included loss of dignity, feeling that they were a burden on family, friends, society, 59%, and that pain motivation was actually down at 30%, quite low on the list. So again, I just encourage you, look into this. Think hard, somehow get to that point where you can lay aside some of your personal struggle with the concept and just really try and analytically look at the law and test if this is the right one. Again, encourage you, if you want more, there's plenty of good stories in the book that I've written. Please get a copy and enjoy the rest of this conversation and webinar. Thanks for listening.
All right, lots to think about. And if you do read Carolisa's book, you will find an interview with our next 2 speakers. First up, we have Dr. Jack Havel, ex-president of the End of Life Choice Society, retired ICU medical specialist, and co-author of the book Dying Badly. Welcome, Jack.
Thank you very much. Now, I'm going to talk in 5 minutes why one should support the End of Life Choice Act. It allows people to choose a good death when a bad death seems likely. A good death can occur where the terminally ill, mentally competent, and badly suffering patient is given medical help to die at their request. Their loved ones can be with them, and ceremonies can be held as wanted while they are still awake. Many describe them as beautiful occasions, and this can, in some circumstances, avoid a drawn-out, terrible time at the end of life. Even with the best hospice and palliative care, a significant number of patients suffer unbearably as they die. In the Australian studies, 5 to 10%. Also in this book, if you want to read it, it's on endoflifechoice.org.nz. There's lots of stories that will break your heart. And they were from submissions to the Select Committee. This law will give those who want it an option to request life-ending medication and decide for themselves when their suffering becomes unbearable. Now, research has confirmed in the jurisdictions where laws have already been passed to allow assisted dying, they're working well. In some places, assisted dying is comfortably integrated with hospice and palliative care to give seamless care. For instance, Belgium and in places in California. It's time that our New Zealand palliative care and hospice organisations look seriously at this option instead of turning up their nose at it. There's no evidence of abuse or coercion of the elderly, disabled, vulnerable. Trust in doctors is high. In legalised jurisdictions where measured suicides have not risen. New Zealand Act is one of the strictest in the world with a clear and thorough process, multiple safeguards and automatic review systems. The majority of New Zealanders and MPs support the choice for terminally ill at the end of their life. Many doctors and nurses, contrary to what is said by many, support the End of Life Choice Act becoming law. Studies show that 38% of GPs, 11% not sure, support the terminally ill Act, the things in our terminally ill Act. And 70% of nurses at least support assisted dying in terminal situations. Now, New Zealanders value their autonomy increasingly in medical choices, as doctors will know, and this is no different in the end of life. Many terminally ill patients want to have control of the timing and the manner of their death, and as shown in legalised jurisdictions, take great comfort in knowing that assisted dying is available from the life-ending medication, even if they do not eventually take it. And finally, the study has shown that 5 to 8% of deaths reviewed in the New Zealand Coroner's Court over a period 1950 to 2000 led to dying adults committing suicide to end their suffering. This was more than 1 every 2 weeks, and I suspect it's still going. Often these suicides occurred earlier than assisted dying would have taken place, as the patients wanted to make sure that they could see while they could. So, thank you.
Thank you very much, Jack. Next, we welcome another experienced doctor, this time opposed to the implementation of the End of Life Choice Act. Dr. Sinead Donnelly is Consultant for Internal Medicine in Wellington and Associate Professor of Palliative Medicine. Welcome, Sinead.
Thank you. As Adam has said, the referendum question is not about the idea of euthanasia, but about the robustness of the End of Life Choice Act, which we're asked to vote on. I imagine myself with a patient who's asked for euthanasia if this were legalised. And if we take the words of the Act, it tells us that before the date chosen by the eligible person for the administration of the medication, the doctor must advise the person about the following methods for the administration: ingestion triggered by the person, intravenous delivery triggered by the person, ingestion through a tube triggered by the doctor or the nurse practitioner, injection administered by the doctor or the nurse practitioner, and then ask the person to choose one of the methods. So I imagine myself sitting beside someone and injecting phenobarbital or propofol and ending their life within seconds. And I just feel that we should just stay with that image. Let's stay with that image. This is not a debate where techniques or clever and persuasive arguments should carry the day. It is a matter of evidence. Are we persuaded on a clinical appraisal of the evidence that this law is necessary and justified? So in the words of the Act, it says the meaning of a person who is eligible, as Adam has said, for assisted dying is aged 18 years. And we already know from the Attorney General, 18 years or over, that this is contrary to the New Zealand Bill of Rights and will probably be challenged to lower the age to 16. The person suffers from a terminal illness. So for me, terminal illness as a palliative medicine doctor, it's not a phrase that I use. It's not a scientific term. What exactly is a terminal illness? It's not defined in science or in medicine. And it's likely to end the person's life within 6 months. Now, how good are you? Certainly, how good am I at judging how long they have to live? Most of us cannot determine someone's prognosis for 6 months. It's said that about 2/3 of us get it wrong at that stage. There's a paper from March of this year in the BMJ that says that asking doctors and nurses to determine prognosis within 72 hours, and 1/3 of doctors got it wrong. So that's not a well-defined term either. So how are we going to work within those ill-defined terms? This Act, it says that it excludes people with disability or mental illness alone. If they have those things alone, they're not eligible. However, if you've got an advanced illness and disability, if you have an advanced illness and mental illness, you are eligible. And because of the interplay between the two, disability and advanced illness, mental illness and advanced disease, you are more at risk of being driven to requesting euthanasia. Because in our society, those people with mental illness and with disability are already at a disadvantage. So further words from the Act, because that's what we'll be working with, is that the attending doctor, for example, will personally communicate at intervals by any means, for example, by telephone or electronic communication with the person about the person's wish. So they've expressed their wish for euthanasia, the process is happening, and you are to personally communicate by any means. So I just can't believe that they're suggesting that by telephone, email, or text, we will, as doctors, at intervals, communicate with the patient. Another phrase is encourage the person to discuss their wish with others, such as family and friends. So all we have to do is encourage, but we must ensure that the person knows that they're not obliged to discuss their wish with anyone. So in fact, it is possible that such a person requesting euthanasia, their family would not know, and it is possible that they will only be 18 years of age. The doctor is to do their best to ensure that the person expresses their wish free from pressure, like free from coercion. What is do your best? That's not well defined, and it seems like a very low bar to me. So another phrase is that you're to ask the psychiatrist for the psychiatrist's opinion. So, but it's not actually about whether you think the person might be suffering from depression or anxiety or mental illness. The only reason you're to ask the psychiatrist is to determine if they're competent, as Adam has referred to make an informed decision about assisted dying. That is that this will cause their death. So that's the only stipulation that you would require a psychiatrist. So already among the lay people, among all the people of New Zealand, there's confusion regarding the terminology, and it's widespread among the public. Many New Zealanders appear to falsely believe that the End of Life Care Choice Act applies to end-of-life practices currently legal, such as turning off life support, implementing do not resuscitate requests, and ceasing active investigation and treatment. All those are already legal, and the public are confusing this act with these opportunities or these options. So the End of Life Choice Act stipulates that euthanasia cannot be indicated on the death certificate. It doesn't require, as we've already heard, a cooling off period between the request and implementation. It doesn't require an independent witness at any stage of the process. And it doesn't require that the doctor reconfirm competence when the patients affirm the decision to proceed with administration of the lethal substance. So the decision required of each of us in the forthcoming election requires no less than being satisfied beyond reasonable doubt that the law should be passed. It is not sufficient that the law appear to be a good idea. Just as juries are warned about the risks of bias and being swayed by emotion, so too should we be very certain. Thank you.
Thank you very much, Sinead. When considering the implementation of a new law in New Zealand, especially one that is to impact the health system, it is important we hear voices of tangata whenua. Improving Māori health outcomes remains a focus for the Ministry of Health, but could the End of Life Choice Act help or hinder this goal? Here to give us insight on views from a Māori perspective, I'd like to welcome back Hector Matthews.
Kia ora, Shelley. Kia ora koutou. And thank you for the opportunity to offer a Māori perspective, bearing in mind that Māori are not homogenous like all other groups. So while most people look at, look at this referendum as a choice between allowing assisted dying or not, I'm going to offer a different perspective. This referendum is about mana and tino rangatiratanga. Tino rangatiratanga can mean many different things, but in this context, I mean the right of Māori to control their own lives. I am neither pro nor anti-assisted dying. I am pro tino rangatiratanga. Māori people have been colonised. Legislation has been a favoured tool of colonisation used to disempower and dispossess. Our right to speak our language, practice our culture, and decide how we wish to live have all been systematically taken away through various pieces of legislation in New Zealand. The process of colonisation, along with religion, have also shifted and tainted Māori views from traditional viewpoints about death and dying. Death and dying are very tapu subjects, which whānau can be reluctant to discuss. Tapu as a concept is also often misunderstood and has now become a product of colonisation, having been taken and used by Christianity to mean something very different than it did in pre-European times. However, death and dying can be broached with whānau if it is done with aroha and considers the importance of whānau and whakapapa. People will reach their own solutions. One of the most obvious systemic biases of Western medicine is the default position it takes towards the patient at the exclusion of the whānau. While it is true that the patient always retains their tino rangatiratanga in any decision-making, medicine has never really understood the Māori view that people exist as a part of their whakapapa and their whānau, meaning that the default position should always be that whānau need to be involved. So firstly, and most importantly, this referendum must be considered in the light of tino rangatiratanga and how this may or may not affect the right of Māori to make their own decisions about their lives without the government, without agents of the state or Pākehā morals impinging on those rights. Māori have consistently argued that the laws in New Zealand frequently take away their mana, their tino rangatiratanga, the ability of individuals and whānau to decide for themselves what their pathway, their journey, and their decision should be. Too often the law directs us down a path which is not in line with our values, and we are told what we must do, rather than having the right to decide for ourselves. Evidence and data consistently show that this process of colonisation and the intergenerational trauma that it causes adversely impacts on health outcomes and health equity for Māori. Anything that arrests the erosion of tino rangatiratanga is therefore more likely to aid Māori health outcomes and improve health equity in New Zealand. This is what is at the heart of this referendum and what makes it so confronting for our society and indeed for Māori people. Who decides is an issue of mana, of tino rangatiratanga. Let us consider this referendum in terms of tino rangatiratanga. Who decides how we, as Māori, live our lives, or in some cases, choose the nature and timing of impending death? Let us set aside the moralising or otherwise about assisted dying, and let us focus on who should decide on tino rangatiratanga. Kia ora koutou. Thank you, Shelley.
Thank you so much for that perspective. That really is important to hear. The Ministry of Health is also committed to improving health outcomes and reducing inequalities experienced by Pacific peoples in New Zealand. Here to present some considerations about the Act from a Pacific perspective, I'd like to welcome Ate Moala. Dr. Moala is a public health physician. She is Clinical Director at Pacific Orthopedics. Malolele, Ate.
Malolele, Shirley, malolele, everyone. Warm Pacific greetings. Thank you for the opportunity to give a Pacific perspective on this important End of Life Choice Act. As we are aware that the majority of the submissions to the Select Committee regarding the bill, there were a significant majority who were opposed to the bill, which is now an act. The good news is that Pacific people still trust doctors. They still want to be guided by doctors, but that has taken a long time for Pacific people to, to trust Western medicine. But that will change. In our Pacific languages, there's no word for euthanasia. We have a word for suicide, but not a single Pacific Island language have got a word for euthanasia or assisted suicide. So euthanasia and assisted suicide is not a Pacific paradigm. It's not part of our Pacific worldview. There is a lot of confusion still, not only with my Pacific people, but in the New Zealand public, there was 8 to 9 out of 10 people still thought that when we're discussing euthanasia, we are talking about turning off life support, the do not resuscitate, withholding treatment when it's no longer considered effective. So that is in the New Zealand public, in mainstream. With Pacific people, there is probably 99% of the people, absolutely a lot of confusion about that. And they do not know that, withholding withdrawing treatment at the end of life with palliation, they do not differentiate that with this, ending life deliberately through euthanasia. So that's an important consideration for our patients who are Pacific. A major concern for Pacific people is, this act is very individualistic in its approach, very similar to what Hector had raised about, Māori and the whānau. Pacific do everything with families. Families, everything is done within families. So, it is distressing when, when Sinead was, outlining that there's no obligation that, that we have to tell the patient who's considering the euthanasia that they're not obliged to tell their family or anyone else. There is, from a Pacific perspective, that is quite unsafe. As you know, when we have a funeral, we'll wait for up to 2 weeks until family come from overseas, and and not only from from New Zealand, but America, and we wait and we wait. But at the moment, like for me, for example, I'm the main caregiver for my 94-year-old mom, who is very healthy. But if I go to Auckland for a meeting and I come back a week later and she has pneumonia in the hospital, and with with the language barrier, if there's confusion already, and and with not having a cooling period, a cooling off period, I think there's something in the act about 48 hours compared to to the 2 weeks overseas. Imagine what I have to, what do I have to say to my family, when they come for my mother's funeral, if she had chosen euthanasia without telling anybody. I am the one responsible, and all my, brothers and sisters here in New Zealand. It will unravel the families. I'll have to put up with the shame. I'll have to explain what I can't explain. And it's not just me. I'm just giving that as an example of the value of families in Pacific communities for your consideration. We all know the poor health outcome, the poor access, the inequality of health outcomes for Pacific is because of inequality of access to care. They present late. I don't have to remind you that, they turn up late. And by the time, they come, it's, the time is quite short. And, and we know the high association, whether it's diabetes, non-communicable disease, and a higher correlation with mental health illness and depression. We have issues with our Pacific young people, the high suicide rates. 18, 19-year-olds, if they don't tell, they're already killing themselves without telling anybody. And now if somebody tell them you don't have to tell anybody else, it will unravel the families, the strength of the Pacifica families. The important to know, the important thing to know is that the poor access to healthcare, it's a main issue, and there's poor access to palliative care. Please remember that for your Pacific patients.
Thank you so much, Ati. So thank you to all our speakers. Let's look at what questions are coming through. How can we deal with the discussion if a family member asks about assisted dying in front of the patient, but the patient themselves has not raised the issue? Can we legally discuss this at that point with the patient?
The Act provides explicitly for assisted dying not being initiated by a health practitioner. So Section 10 is explicit that it's not for the doctor to raise the concept of assisted dying. What the question describes is a great example of the sort of complex real world situations that doctors will get confronted with and then have to figure out how that works with the legislative framework. If someone rang me up with that question, I would say no. The fact that a family member has raised it is not the same as the patient having raised it. And so it would be contrary to the Act for you to springboard off that to have a discussion about assisted dying. It's only lawful for that discussion to take place if it is raised by the patient. Interestingly, though, that Section 10 is again explicit that situations where a doctor is found to have proactively raised dying, not an offence under the Act, but it can be professional misconduct in terms of the medical council's role in looking into that.
Thank you, Adam. That's a really good and complex question. Next, why has New Zealand gone for euthanasia over assisted suicide? Sorry, I think I jumped.
Well, I can make a few comments on that. People, we don't like the end of life choice, doesn't like the word euthanasia because it echoes what a lot of people talk about Nazis and involuntary. We don't mind voluntary euthanasia, but inevitably opponents of the Act always use euthanasia, but when they really should mean voluntary euthanasia. The other thing about assisted suicide, the term assisted suicide, I know it's used various places in Netherlands and that, but suicide is quite different from assisted dying. Now suicide, irrational suicide, is something where a person is mentally unstable and does it without knowledge of other people and causes a lot of grief, whereas assisted dying is done with, it's more like a medical procedure and discussion and consultation including with the family usually. And so there are problems with the semantics, if you like, but inevitably people use euthanasia and assisted suicide, but it does mislead people.
Yeah, words are really important. I wondered if that question actually meant, though, assisted suicide is the option that Victoria has. Is that correct? When the patient is able to take the medicine,
Yes.
so the doctor doesn't give the final dose.
The doctor gives the dose to the patient to take themselves.
So that is still an option in the Act. Am I correct?
Yes, that's one of the options, and the other
and
option.
So why did New Zealand choose to include both options? I wondered if that's what they were meaning.
Oh, okay.
Is it because of the time frame that what they term assisted suicide, meaning the taking by the patient? Is that because it's less predictable time frame?
There's quite a few reasons. One is that say if you like, if you take places like Belgium and the Netherlands where they've got both options, over 90% of people choose the intravenous route because it's safer and quicker. Whereas the other route is when the patient drinks something and they can vomit and all that sort of thing, and sometimes it can take quite a long time. And so there's quite a few issues around that. Other people feel like in Victoria, they felt happier if the patient takes it themselves and the doctor doesn't have to give it unless it's an extreme situation where the patient can't take it themselves. So there's a lot of discussion around that.
Yes, I hope that answered the question. Thank you. Now, how accurate can we really be with 6-month life expectancy, and how does indemnity cover work if we get it wrong? For example, if we think someone will live more than 6 months, so they're not eligible, so they're not allowed, and then it happens that they die sooner.
Could I comment on that?
Sure, and then we get Adam's comment. Thanks.
Yes, yeah. Basically, they're likely to die within 6 months. In Canadian legislation, their death is foreseeable. Now, basically, if you say you're quite well at 6 months, but you've got a terminal diagnosis, you're not going to want people to knock you off at that stage, but you might want to discuss it with the family, or discuss it with the doctor and ask and get it all set up. But virtually all cases, they have the assisted dying just a few weeks before the end in other jurisdictions. And what that means is that if you're in an advanced stage of incapacity, you're there dying, you're probably, in most places, you're actually in hospice. So everybody's accepted that you're dying and you're going to die soon. And so I think this is a bit of a red herring, that not being able to, sure, if you're a year out or something like that, there's a lot of variation in the times of accuracy. But when you're getting towards the term of death, it's academic. The person's going to die soon, they know it, and they've got unbelievable suffering, an advanced stage of incapacity.
I guess there's concern.
Nobody at that stage.
And how well we can estimate 6 months. Adam, do you have a comment to that one about what if a family felt that they had been wrongly not allowed the assisted dying because they weren't thought to be 6 months, but then they died earlier?
Yeah, that scenario I think would be very unlikely to result in any sort of liability. There isn't a route under the Act to take a civil claim against someone for participating in the process and getting it wrong. Really, the only way in which someone who felt unhappy, presumably a surviving partner or family member, might be able to advance that is if either the getting it wrong was willful, and it's difficult to imagine a scenario where that would be so, or clinically negligent, essentially. Someone just got it so badly wrong that from a competence perspective, they might get referred to the medical council or to the Health and Disability Commissioner for not providing that health service up to the required standard.
All right, thank you. And Sinead, you kind of addressed that a bit in your talk. Would you like to comment to that one?
Which on prognosis?
Yeah, like how accurate our prognosis is.
Yeah, I think it is very important. It's a piece of legislation. I'm not a lawyer, but to have something written down that says a prognosis of 6 months or something that actually we can't get really right. It's a complete guess. It's an art, not a science. We don't plug into the details of the patient into a computer and it produces the date of death from which we can count back. You know, it's a very poor safeguard in my view. And the idea of why people request euthanasia rather than assisted suicide, in Canada it's mainly euthanasia, even though they have the option of both, because people like the doctor to be there. It provides a medical cloak of legitimacy that the doctor sitting beside the person and injecting them. So, I mean, that distresses me, but that's the fact of why people choose euthanasia over assisted suicide.
Thanks for adding that. I'll move on to the next question. Why is assisted dying excluded from being recorded on the death certificate? How on earth can good data be collected if this is excluded? And will there be an alternative way of collecting data about the characteristics of those people who choose assisted dying?
Could I answer that? It is required to be on the death certificate. There's two things: the underlying diagnosis and the fact that they died from assisted dying. That's in the Act.
Yeah, okay, thank you. And do we know how it would work rurally if no doctors are willing? Probably.
Oh, well, I can comment on it if you want me to. I'm talking a lot. But basically, if the unwilling doctor who's been asked refers it to the SENS body, and they will find somebody to take it from there.
And I imagine that would have to be a face-to-face encounter. So
yes,
there will probably be challenges, but and I guess that will mean that there may not be the duration of relationship with the doctor if in some cases.
Yes, that is of course up to the doctor and the patient, because they can see each other from time to time if necessary. It would just prolong and raise the cost of sector.
And next question is, will end-of-life choice be fully funded in New Zealand? Do we know this?
No.
I don't think we do.
Adam, could you speak a little bit to that?
Well, I mean, I don't profess to be an expert in the intricacies of public health funding. I suspect that the work that will be required to go into that will follow the vote, because we don't know yet whether this law will actually come into force. But it is an issue that needs to be grappled with, because I don't know how likely it is that someone will have to engage with this in a primary care setting, but if you were dealing with a candidate, for want of a better word, for assisted dying as a GP, in order to meet your obligations under the Act, make the assessments, liaise with the registrar, liaise with the independent doctor who's going to give the second opinion, probably spend a lot of time on the phone to MPS. That's a lot of work, and it seems a little bit off talking about the financial side of it, but it is something that occurred to me anyway going through the Act, is how will that be funded? Obviously, the Vote Health and the Ministry will fund the SCENS group and the review committee and the registrar, but in terms of the actual work of practitioners. And look, I suspect if there is a yes vote, the reality is that there will be doctors who are supporters of assisted dying or voluntary euthanasia, whatever words we choose, who see it as part of their practice to be involved in this irrespective of the finances.
Yeah, it does seem like it's an important thing to consider, especially knowing whether it will come out of the current kind of health funding, another system being put into an already stretched service. Okay, that one's been done. Can someone talk about the declaratory judgment from Hospice New Zealand versus Attorney General in regards to organisational conscientious objection and the attending practitioner?
I could give a brief non-answer to that, to that. Non-answer only because there were a group led by Hospice New Zealand, and then there were other parties involved as well, who, once the legislation was passed, so we knew what it is we're voting on, took a court case in what's called a declaratory judgment, which is where they approached the court to ask the court to help interpret the law. It's an odd thing for the court to be asked to interpret a law which may never come into force, but it's an 83-page judgment, so it's probably not something that's easily condensable. Really great document to read, though, as I guess an entree into how the court might start to think about these sorts of issues and approach interpreting the Act. I don't have at my fingertips sort of all of the things that the court said, but the heart of the case were those organisations testing whether or not they, as organisations, could be conscientious objectors, because the Act is focused on allowing individuals to be conscientious objectors, and then it provides a protection for those individuals in terms of not being disadvantaged in their employment because they are conscientious objectors. But there are a number of organisations which are at an organisational level ethically opposed to assisted dying, and were trying to get as much guidance from the court as they could about whether they could declare themselves as being at that level objectors to the Act, and then have all of their staff, not involved.
And another point I think was made through that, they were asking whether the palliative care or hospice would lose its funding or would be impacted in its funding if it took a conscientious objection as an institution. Would it lose its funding from palliative care funding from the state? And I don't think that was resolved.
Testing my memory, Sinead, but I think that was one of the questions the court said it's just not for us to answer that at this stage, and really not for the court to answer full stop. That's for the government and the ministry.
That is what has happened in Canada, that some of the hospices have been, their funding has been threatened because they, as a group, didn't want to participate. So they lost their government funding to provide palliative care.
The basic issue there is that if you've got a public act, whether a faith-based organisation has the right to exclude assisted dying from their premises, but accept public money, that's a basic issue. And the court didn't decide on that.
Okay, I've got maybe one more. With the move towards advanced directives, will a patient be able to put a directive that if they become terminally ill in future, they want this? Will this stand legally?
That's an easy one. No.
What if What if a patient's EPOA requests this? Can't.
No, it's excluded specifically by the Act. It's excluded. There's a lot of us would have liked to have that in for patients like dementia, etc., but that was excluded specifically by the Act due to one political party wanting it, insisting that the patient had to be terminal.
Okay. So although many questions remain, it is now time to bring this webinar to a close. We always knew that 1 hour would be a challenge to get all the messages across and all questions answered, but I hope that you feel we have started to be more informed. I'd like to warmly thank all of our speakers this evening, Adam, Caroline, Jack, Sinead, Hector and Ati. I'd also like to acknowledge all the voices that we have not heard tonight. We have not heard perspectives from doctors experienced in assisted dying from overseas, nor have we heard perspectives from New Zealanders with disabilities or those currently at the end of life, and I'm sure there's many more. Our final slide, when it comes, offers links that can help you find more detailed information and perspectives. Please take a screenshot of this so that you can get more informed. Can I have final messages from each of our speakers, starting with you, Adam?
Oh, look, it's a privilege to be able to speak at this, Shelley. I can only scratch the surface in the time available. I'll link up with you so that if there is some ability to address some of the questions that are outstanding, I'm happy to put a little bit of work into that, and we can maybe find a way to reach out to participants and provide a bit more of information.
Thank you so much. Jack?
Well, the essence of the Act is to allow patients approaching death with unrelievable suffering to request help to die from a medical practitioner, and just pretend it's you.
Thank you. Sinead?
I suppose I'm one of 1,660 doctors who've signed up in New Zealand. Doctors Say No, and our particular concern is protecting vulnerable people who we meet every day. And these people who feel they've become a burden to others, and we feel that they're at great risk due to the way this Act is written. So you can be in favour of euthanasia as an idea, even for yourself, but this Act, it has not got enough safeguards to protect the vulnerable.
Thank you, Sinead. And Hector?
I'd end with a simple phrase in te reo Māori, kai hea te tino rangatiratanga. Where is the tino rangatiratanga? Kai roto i ahau, kai roto i a tātou. It's within me, it's within all of us.
Thank you, Hector. Ate?
Thank you. Just remember that this Act it alienates Pacific families. It's not part of our Pacific worldview, and it will not help with the doctor-patient relationship.
Thank you so much, everybody. Good night. Have a lovely evening, and any questions, we'll follow up. Thank you.
Kia ora, thank you.
Thank you, Shelley.